Article 4. Construction in favor of labor. All doubts in the implementation and interpretation of the provisions of this code, including its implementing rules and regulations, shall be resolved in favor of labor. Article 26. Travel agencies prohibited to recruit. Travel agencies and sales agencies of airline companies are prohibited from engaging in the business of recruitment and placement of workers for overseas employment, whether for profit or not. Article 27. Citizenship requirement. Only Filipino citizens or corporations, partnerships, or entities at least 75% of the authorized and voting capital stock of which is owned and controlled by Filipino citizens shall be permitted to participate in the recruitment and placement of workers, locally or overseas. Article 28. Capitalization. All applicants for authority to hire or renewal of license to recruit are required to have such substantial capitalization as determined by the Secretary of Labor. Article 29. Non-transferability of license or authority. No license or authority shall be used directly or indirectly by any person other than the one in whose favor it was issued, or at any place other than that stated in the license or authority be transferred, conveyed, or assigned to any other person or entity. Any transfer of business address, appointment or designation of any agent or representative, including the establishment of additional offices anywhere, shall be subject to the prior approval of the Department of Labor. Article 38. Illegal recruitment. A. Any recruitment activities, including the prohibited practices enumerated under Article 34 of this code, to be undertaken by non-licensees or non-holders of authority, shall be deemed illegal and punishable under Article 39 of this code. The Department of Labor and Employment or any law enforcement officer may initiate complaints under this article. B. Illegal recruitment when committed by a syndicate or in large scale shall be considered an offense involving economic sabotage and shall be penalized in accordance with Article 39 hereof. Illegal recruitment is deemed committed by a syndicate if carried out by a group of 3 or more persons conspiring and or confederating with one another in carrying out any unlawful or illegal transaction, enterprise, or scheme defined under the first paragraph hereof. Illegal recruitment is deemed committed in large scale if committed against 3 or more persons individually or as a group. C. The Secretary of Labor and Employment or his duly authorized representative shall have the power to cause the arrest and detention of such non-licensee or non-holder of authority if, after investigation, it is determined that his activities constituted danger to national security and public order or will lead to further exploitation of job seekers. The Secretary shall order the search of the office or premises and seizure of documents, paraphernalia, properties, and other implements used in illegal recruitment activities, and the closure of companies, establishments, and entities found to be engaged in the recruitment of workers for overseas employment, without having been licensed or authorized to do so. Article 40. Employment permit of non-resident aliens. Any alien seeking admission to the Philippines for employment purposes, and any domestic or foreign employer who desires to engage an alien for employment in the Philippines shall obtain an employment permit from the Department of Labor. The employment permit may be issued to a non-resident alien or to the applicant employer after a determination of the non-availability of a person in the Philippines who is competent, able, and willing at the time of application to perform the services for which the alien is desired. For an enterprise registered in preferred areas of investments, said employment permit may be issued upon recommendation of the government agency charged with the supervision of said registered enterprise. Article 61. Contents of apprenticeship agreements. Apprenticeship agreements, including the wage rates of apprentices, shall conform to the rules issued by the Secretary of Labor and Employment. The period of apprenticeship shall not exceed 6 months. Apprenticeship agreements providing for wage rates below the legal minimum wage, which in no case shall start below 75% of the applicable minimum wage, may be entered into only in accordance with apprenticeship programs duly approved by the Secretary of Labor and Employment. The department shall develop standard model programs of apprenticeship. Article 84. Hours worked. Hours worked shall include a. All time during which an employee is required to be on duty or to be at a prescribed workplace, and b. All time during which an employee is suffered or permitted to work. Rest periods of short duration during working hours shall be counted as hours worked. Article 87. Overtime work. Work may be performed beyond 8 hours a day provided that the employee is paid for the overtime work, an additional compensation equivalent to his regular wage plus at least 25% thereof. Work performed beyond 8 hours on a holiday or rest day shall be paid an additional compensation equivalent to the rate of the first 8 hours on a holiday or rest day plus at least 30% thereof. Article 94. Right to holiday pay. A. Every worker shall be paid his regular daily wage during regular holidays, except in retail and service establishments regularly employing less than 10 workers. B. The employer may require an employee to work on any holiday, but such employee shall be paid a compensation equivalent to twice his regular rate. And C. As used in this article, holiday includes New Year's Day, Maundy Thursday, Good Friday, the 9th of April, the 1st of May, the 12th of June, the 4th of July, the 30th of November, the 25th and 30th of December, and the day designated by law for holding a general election. Article 95. Right to service incentive leave. A. Every employee who has rendered at least 1 year of service shall be entitled to a yearly service incentive leave of 5 days with pay. B. This provision shall not apply to those who are already enjoying the benefit herein provided, those enjoying vacation leave with pay of at least 5 days, and those employed in establishments regularly employing less than 10 employees or in establishments exempted from granting this benefit by the Secretary of Labor and Employment after considering the viability or financial condition of such establishment. C. The grant of benefit in excess of that provided herein shall not be made a subject of arbitration or any court or administrative action. Article 100. Prohibition against elimination or diminution of benefits. Nothing in this book shall be construed to eliminate or in any way diminish supplements or other employee benefits being enjoyed at the time of promulgation of this code. Article 106. Contractor or subcontractor. Whenever an employer enters into a contract with another person for the performance of the former's work, the employees of the contractor and of the latter's subcontractor, if any, shall be paid in accordance with the provisions of this code. In the event that the contractor or subcontractor fails to pay the wages of his employees in accordance with this code, the employer shall be jointly and severally liable with his contractor or subcontractor to such employees to the extent of the work performed under the contract, in the same manner and extent that he is liable to employees directly employed by him. The Secretary of Labor and Employment may, by appropriate regulations, restrict or prohibit the contracting out of labor to protect the rights of workers established under this code. In so prohibiting or restricting, he may make appropriate distinctions between labor-only contracting and job contracting, as well as differentiations within these types of contracting, and determine who among the parties involved shall be considered the employer for purposes of this code, to prevent any violation or circumvention of any provision of this code. There is labor-only contracting where the person supplying workers to an employer does not have substantial capital or investment in the form of tools, equipment, machineries, work premises, among others, and the workers recruited and placed by such person are performing activities which are directly related to the principal business of such employer. In such cases, the person or intermediary shall be considered merely as an agent of the employer who shall be responsible to the workers in the same manner and extent as if the latter were directly employed by him. Article 109. Solidary liability. The provisions of existing laws to the contrary notwithstanding, every employer or indirect employer shall be held responsible with his contractor or subcontractor for any violation of any provision of this code. For purposes of determining the extent of their civil liability under this chapter, they shall be considered as direct employers. Article 128. Visitorial and enforcement power. A. The Secretary of Labor and Employment or his duly authorized representatives, including labor regulation officers, shall have access to employers' records and premises at any time of the day or night whenever work is being undertaken therein, and the right to copy therefrom, to question any employee and investigate any fact, condition, or matter which may be necessary to determine violations or which may aid in the enforcement of this code, and of any labor law, wage order, or rules and regulations issued pursuant thereto. B. Notwithstanding the provisions of Articles 129 and 217 of this code to the contrary, and in cases where the relationship of employer-employee still exists, the Secretary of Labor and Employment or his duly authorized representative shall have the power to issue compliance orders to give effect to the labor standards provisions of this code and other labor legislation based on the findings of labor employment and enforcement officers or industrial safety engineers made in the course of inspection. The Secretary or his duly authorized representatives shall issue writs of execution to the appropriate authority for the enforcement of their orders, except in cases where the employer contests the findings of the labor employment and enforcement officer and raises issues supported by documentary proofs, which were not considered in the course of inspection. An order issued by the duly authorized representative of the Secretary of Labor and Employment under this article may be appealed to the latter. In case said order involves a monetary award, an appeal by the employer may be perfected only upon the posting of a cash or surety bond issued by a reputable bonding company duly accredited by the Secretary of Labor and Employment in the amount equivalent to the monetary award in the order appealed from. C. The Secretary of Labor and Employment may likewise order stoppage of work or suspension of operations of any unit or department of an establishment when noncompliance with the law or implementing rules and regulations poses grave and imminent danger to the health and safety of workers in the workplace. Within 24 hours, a hearing shall be conducted to determine whether an order for the stoppage of work or suspension of operations shall be lifted or not. In case the violation is attributable to the fault of the employer, he shall pay the employees concerned their salaries or wages during the period of such stoppage of work or suspension of operation. D. It shall be unlawful for any person or entity to obstruct, impede, delay, or otherwise render ineffective the orders of the Secretary of Labor and Employment or his duly authorized representatives issued pursuant to the authority granted under this article, and no inferior court or entity shall issue temporary or permanent injunction or restraining order or otherwise assume jurisdiction over any case involving the enforcement orders issued in accordance with this article. E. Any government employee found guilty of violation of or abuse of authority under this article shall, after appropriate administrative investigation, be subject to summary dismissal from the service. F. The Secretary of Labor and Employment may, by appropriate regulations, require employers to keep and maintain such employment records as may be necessary in aid of his visitorial and enforcement powers under this code. Article 294. Security of tenure. In cases of regular employment, The employer shall not terminate the services of an employee except for a just cause or when authorized by this title. An employee who is unjustly dismissed from work shall be entitled to reinstatement without loss of seniority rights and other privileges, and to his full back wages, inclusive of allowances, and to his other benefits or their monetary equivalent computed from the time his compensation was withheld from him up to the time of his actual reinstatement. Article 295. Regular and casual employment. The provisions of written agreement to the contrary notwithstanding and regardless of the oral agreement of the parties, an employment shall be deemed to be regular where the employee has been engaged to perform activities which are usually necessary or desirable in the usual business or trade of the employer, except where the employment has been fixed for a specific project or undertaking the completion or termination of which has been determined at the time of the engagement of the employee, or where the work or service to be performed is seasonal in nature and the employment is for the duration of the season. An employment shall be deemed to be casual if it is not covered by the preceding paragraph, provided that any employee who has rendered at least 1 year of service, whether such service is continuous or broken, shall be considered a regular employee with respect to the activity in which he is employed, and his employment shall continue while such activity exists. Article 296. Probationary employment. Probationary employment shall not exceed 6 months from the date the employee started working, unless it is covered by an apprenticeship agreement stipulating a longer period. The services of an employee who has been engaged on a probationary basis may be terminated for a just cause or when he fails to qualify as a regular employee in accordance with reasonable standards made known by the employer to the employee at the time of his engagement. An employee who is allowed to work after a probationary period shall be considered a regular employee. Article 297. Termination by employer. An employer may terminate an employment for any of the following causes. A. Serious misconduct or willful disobedience by the employee of the lawful orders of his employer or representative in connection with his work. B. Gross and habitual neglect by the employee of his duties. C. Fraud or willful breach by the employee of the trust reposed in him by his employer or duly authorized representative. D. Commission of a crime or offense by the employee against the person of his employer or any immediate member of his family or his duly authorized representatives, and E. Other causes analogous to the foregoing. Article 298. Closure of establishment and reduction of personnel. The employer may also terminate the employment of any employee due to the installation of labor-saving devices, redundancy, retrenchment to prevent losses, or the closing or cessation of operation of the establishment or undertaking, unless the closing is for the purpose of circumventing the provisions of this title, by serving a written notice on the workers and the Ministry of Labor and Employment at least 1 month before the intended date thereof. In case of termination due to the installation of labor-saving devices or redundancy, the worker affected thereby shall be entitled to a separation pay equivalent to at least his 1 month pay or to at least 1 month pay for every year of service, whichever is higher. In case of retrenchment to prevent losses and in cases of closures or cessation of operations of establishment or undertaking not due to serious business losses or financial reverses, the separation pay shall be equivalent to 1 month pay or at least 1/2 month pay for every year of service, whichever is higher. A fraction of at least 6 months shall be considered 1 whole year. Article 300. Termination by employee. A. An employee may terminate without just cause the employee-employer relationship by serving a written notice on the employer at least 1 month in advance. The employer upon whom no such notice was served may hold the employee liable for damages. B. An employee may put an end to the relationship without serving any notice on the employer for any of the following just causes. 1. Serious insult by the employer or his representative on the honor and person of the employee. 2. inhuman and unbearable treatment accorded the employee by the employer or his representative. 3. Commission of a crime or offense by the employer or his representative against the person of the employee or any of the immediate members of his family. And 4. Other causes analogous to any of the foregoing. Article 301. When employment not deemed terminated. The bona fide suspension of the operation of a business or undertaking for a period not exceeding 6 months, or the fulfillment by the employee of a military or civic duty shall not terminate employment. In all such cases, the employer shall reinstate the employee to his former position without loss of seniority rights if he indicates his desire to resume his work not later than 1 month from the resumption of operations of his employer or from his relief from the military or civic duty. Article 302. Retirement. Any employee may be retired upon reaching the retirement age established in the collective bargaining agreement or other applicable employment contract. In case of retirement, the employee shall be entitled to receive such retirement benefits as he may have earned under existing laws and any collective bargaining agreement and other agreements, provided, however, that an employee's retirement benefits under any collective bargaining and other agreements shall not be less than those provided therein. In the absence of a retirement plan or agreement providing for retirement benefits of employees in the establishment, an employee upon reaching the age of 60 years or more, but not beyond 65 years, which is hereby declared the compulsory retirement age, who has served at least 5 years in the said establishment, may retire and shall be entitled to retirement pay equivalent to at least 1/2 month's salary for every year of service, a fraction of at least 6 months being considered as 1 whole year. Unless the parties provide for broader inclusions, the term 1/2 month's salary shall mean 15 days plus 1/12 of the 13th month pay and the cash equivalent of not more than 5 days of service incentive leaves. An underground mining employee upon reaching the age of 50 years or more, but not beyond 60 years, which is hereby declared the compulsory retirement age for underground mine workers, who has served at least 5 years as underground mine worker, may retire and shall be entitled to all the retirement benefits provided for in this article. Retail, service, and agricultural establishments or operations employing not more than 10 employees or workers are exempted from the coverage of this provision. Violation of this provision is hereby declared unlawful and subject to the penal provisions under Article 288 of this Code. Nothing in this article shall deprive any employee of benefits to which he may be entitled under existing laws or company policies or practices. Article 305. Offenses. Offenses penalized under this code and the rules and regulations issued pursuant thereto shall prescribe in 3 years. All unfair labor practice arising from Book V shall be filed with the appropriate agency within 1 year from accrual of such unfair labor practice. Otherwise, they shall be forever barred. Article 306. Money claims. All money claims arising from employer-employee relations accruing during the effectivity of this code shall be filed within 3 years from the time the cause of action accrued. Otherwise, they shall be forever barred. All money claims accruing prior to the effectivity of this code shall be filed with the appropriate entities established under this code within 1 year from the date of effectivity, and shall be processed or determined in accordance with the implementing rules and regulations of the code. Otherwise, they shall be forever barred. Workmen's compensation claims accruing prior to the effectivity of this code, and during the period from November 1st, 1974 up to December 31st, 1974, shall be filed with the appropriate regional offices of the Department of Labor not later than March 31st, 1975. Otherwise, they shall forever be barred. The claim shall be processed and adjudicated in accordance with the law and rules at the time their causes of action accrued.